There are three instances in which a data protection officer should be appointed. The first is if you're a government agency. The second factor to consider is whether your company's fundamental activities require processing, which leads to large-scale or systematic regular monitoring. To clarify the terminology, core activities are components of your organisation that are fundamental business operations. So an example of this may be paying your staff, which is certainly vital, but it's not a core activity in the sense that it's not a significant business operation. So an example would be a hospital that's processing patient records. Processing those patient records is a core activity of a hospital. When we talk about large scale, there isn't really a clear definition of what large scale means, but GDPR does tell you the kinds of things that you need to consider. The amount of data being processed, the number of data subjects, the range of data being processed, the duration and permanence of the processing, and the geographical scope of the processing are all things to consider when deciding whether or not something is large scale. There are certain types of data which are considered to be large scale, so hospital patient data, insurance companies, or banks processing data, that's normally on a large scale. Systematic and regular are self-explanatory. Regular is something that occurs at repeated intervals over a specific period of time. Systematic is according to a system. It's methodical, it's according to a set plan for data processing. It's something that would be systematic monitoring. Might be operating in a telecommunications network, or something like CCTV would also be systematic monitoring. The third situation in which you'd have to appoint a DPO is if your core activities resulted in the processing of special categories of data or data relating to criminal convictions on a large scale. Now, data relating to criminal convictions is fairly self-explanatory. Special categories of data, that's what used to be known as sensitive personal data, so things like political opinions, racial or ethnic origin, religious beliefs, sexual orientation, those are all special categories of data. There are a couple of new ones introduced by the GDPR, so biometric data and genetic data, but it's quite rare that you'd have to deal with those. If you decide not to appoint a data protection officer, you should document your reasons and analysis for not appointing one so that you can show that you've considered the three instances if you're ever questioned in the future. You should also consider voluntary appointing a DPO, even in light of all of the relevant requirements and criteria. It's not really mandatory for you. It's useful for the organisation to have a DPO to show compliance. If you're really against it though, you could consider a less formal role of something like a data protection manager, who maybe wouldn't have as many things to do as a DPO, but it would still help with compliance in the organisation. A DPO's role includes monitoring compliance for GDPR through monitoring processing activities and advising the organisation on those processing activities. Another aspect of the role would be to help with data protection impact assessments, or DPIAs. So that would be either advising on how to do one, whether one is actually necessary, looking at the results of any DPIAs as well, and explaining whether or not the results of a DPIA are in compliance with data protection law. Another aspect of the role will be to consult with and be a point of contact for the supervisory authority. In the UK, that's the Information Commissioner's Office, or ICO, which we'll look at in more detail in the next lesson. And then finally, DPOs do the record keeping, so keeping records of data processing activities and keeping records of DPIAs.